You think it is absolutely no accident that that was the date that this happened. Exactly 36 years before Maduro's capture, Noriega surrendered to U.S. authorities and is flown to Miami to face trial. Noriega raises multiple defenses. Head of state immunity. He argues that as the de facto head of state of Panama, he is entitled to immunity from prosecution. The court rejects this. And again, you're going to see this is exactly why the United States in 2024 decided at that time, after there was dispute over the election, that they were no longer recognizing Maduro as a head of state. And this is why, because they're going to make that the reason why they're going to say he should not receive head of state immunity privilege. And the court held that it can be withheld or granted, and that the U.S. had, and that one of the factors is that the U.S. had never recognized Noriega as Panama's legitimate ruler. Now, Maduro is a bit different because the world recognizes him as a legitimate leader. He was elected, even if it was disputed. And the question at hand will be, is it enough that just the United States government simply says, we're not recognizing him as a leader? Is that enough? And that's going to be up before the United States Supreme Court. That will travel through the 2nd District or to the 2nd District Appeals Court or 2nd Circuit Appeals Court. It's going to go all the way up, and that's going to be decided, and we'll see what they say. Illegal capture. Noriega argued that the manner of his capture through a military invasion was shocking to the conscience and in violation of the laws and norms of humanity. The court rejects this under Kerr-Frisbee, but you're going to hear the shocking to the conscience is what the basis is going to be, and it may be viewed a tad bit different here, and we're going to go over that. And then there was an extradition treaty violation. Noriega argues that his capture violated the U.S.-Panama extradition treaty. Citing Alvarez-Machain, the court rejects this, holding that the treaty did not explicitly prohibit the method by which he was brought to the United States, which is kidnapping. So that I don't know whether or not, I don't know what the treaty is, but I'm assuming that's not included in any extradition treaties. So again, a dangerous precedent that is set. If it's not included, United States courts are going to recognize it, and that means that what's good for the goose is good for the gander. It could happen to our leader if somebody decided to come in and get that stupid. But, you never know. Prisoner of war status. Noriega claimed that as a prisoner of war under the Geneva Convention that the court lacked jurisdiction. The court acknowledged his POW status, but held that the Geneva Convention permits prosecution for pre-capture crimes like drug trafficking. Noriega was eventually convicted in 1992 on 8 of 10 counts, sentenced to 40 years in federal prison. He served 20 in the United States. He was extradited to France in 2010, served a sentence for money laundering there, and then back to Panama in 2011, and he ended up passing away in 2017 at 83. Now, we break it down here for you, okay? And again, this is all on our website. Why this is a much different case. This is not Noriega 2.0. The parallels look similar, but there is a lot of differences. So let's go over them. Status. 1989. Noriega was a de facto military leader who never won an election. Maduro in 2026 is an elected president, regardless of how disputed that election was. I mean, after all, we have disputed elections here. So, this again is a very dangerous president, recognized by a majority of world nations. Declaration of war. There was no declaration of war by Maduro or Venezuela on the United States. Panama's National Assembly did declare war on the United States, making this a completely different situation. America's presence. There was 10,000 troops already stationed in Panama. There was absolutely no U.S. military presence in Venezuela prior to this invasion. Strategic assets. The United States had no comparable assets to the Panama Canal neutrality at stake. That was already something that was in effect. There's no comparable U.S. strategic asset near Venezuela or at Venezuela besides oil. Civilian casualties. Estimated hundreds of Panamanian civilians have been killed. Unknown but reported. Investigations ongoing. International response. The UN General Assembly condemned the invasion 75-20. Clearly, there's not been time for any type of UN assembly, but it's been at this point today, based on news reports, near universal condemnation, even by our closest allies like the UK, France, Germany. All of them have condemned this act. And the UN Security Council is apparently going to be convening a emergency meeting at some point in the near future. Congressional authorization, none in either case. And post-capture governance, U.S. recognized Guillermo Endara as president. Panamanian government continued. Trump announces that the U.S. will run Venezuela temporarily, which really throws a really different look on this, and not a good one for us. The critical distinction that's going to echo through the legal proceedings is that when the U.S. invades Panama, Noriega had declared war. American citizens were allegedly in danger that were in the area. Troops were already on the ground. And none of those conditions existed at all in Venezuela at the time this happened. One retired Army colonel puts it, there, and this is somebody who was quoted today, there were tens of thousands of Americans in Panama allegedly in danger. Noriega had declared war on the U.S., and neutrality and protection of Panama was at risk. And none of that is here. It's not even close to being the same situation. So the questions, let's go over the legal questions, because this is where we are concerned about right now on this channel. This is what you'll be watching. This is what you need to understand as a viewer of this channel, and someone who is concerned about due process, because it's in due process we trust. It's in due process that we believe, or I believe, my father believed, that ensures fairness, and that is what separates us from everyone else, is the belief and that due process applies to everyone, regardless of how heinous the action is, regardless of how terrible the crime is. Now, the first thing that's going to be is a battle over the U.S. non-recognition to strip head of state. The United States has not recognized Maduro as a legitimate president since the disputed election of 2024. But the question is, does that matter, right? Because, again, there might be some countries out there who witnessed some of our elections that were disputed. And would it matter whether or not this other country says, well, I don't believe that was fair? What authority does a country have to simply say, we don't recognize you, especially when the rest of the world does? In the Noriega case, the court held that the head of state immunity is a privilege which the United States may withhold from any claimant. But Maduro isn't a military strongman who seized power in a coup. Some might say he's a military strongman, but he didn't seize power in a coup. He was elected in 2013 and in several disputed elections since. He's been inaugurated. He's recognized by a majority of the world's nations. He's appeared on behalf of these countries as a head of state. He controls the government, the military, and the institutions of Venezuela, of the Venezuelan state. Does America's decision to say, hey, we don't recognize you, automatically convert that leader from head of state into private criminal defendant? And if so, what would stop any future administration from simply refusing to recognize a foreign leader and then claiming the right to invade and arrest them? So this is something that is going to give great pause to the Supreme Court and to any judge who's deciding this. This is going to be controversial, and this is going to be something to watch for. And I can't wait to see how this plays out. The next thing is, at what point is capture too bad for good detention? The Kerr-Frisbee doctrine has survived, as you've seen, over the years. It survived invasion of a small Central American nation. It survived going into Mexico. But can it survive this? Because this operation involved airstrikes on a foreign capital. It destroyed military and civilian infrastructure. It killed civilians and military personnel. The exact number right now is being determined. It created a power vacuum in a country of 28 million people, and it was condemned by everybody. France, Germany, United Kingdom, these are some of our staunchest allies. The Second Circuit in the 1970s did create a narrow exception to Kerr-Frisbee. And it's important because this was in the Second Circuit, the same circuit that will hear this case if it heads out, once it heads out of New York District Court or out of the federal district court in New York. And it was in a case known as United States versus Toscanino. I encourage everyone to look this case up, suggesting that if capture involves the big T, I can't say it, you can see it on the screen, or conduct, and this is the important part, that shocks the conscience. Now, you can see why it's very important when you saw that picture of Maduro blindfolded, but he had a water bottle in his hand, that it's important that the big T is not something that happens, because in that case, in the Toscanino case, the court held that the actions that were taken prior to delivering to the United States were so bad that it shocked the conscience, involved the big T, and thereby he was not going to be tried. It's only been applied that I know of in the Tuscanino case. But Maduro's defense is going to, essentially, this is where we were just talking earlier, the shock the conscience is an invasion against all international laws, coming into a country, bombing. Now, the Trump administration is going to say, no, we were lawful. This is